Welcome to Sakshi TV Special Immigration Show. I'm your host Shivani Raj with Ms. Prashanthi Reddy. Please note that Sakshi TV now has 4 immigration shows every week. On Tuesdays with Kaveti, on Wednesdays with Prashanthi Reddy in English, on Thursdays with Chan Parvatneni, and on Fridays with Banu Nindra. Please do not ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at sakshi.com or call us at 8667257441. Before we begin the show, please note that the information provided on this show is not legal advice and for general informational purposes only. Sakshi TV or its agents will not be responsible for the use of information. But if you need any consultation, you can definitely contact a lawyer directly. So without any further delay, let's welcome Prashanthi Reddy onto our show. Ms. Reddy, I hope you're doing well. Welcome back.
Thanks, Shivani. I'm well. Thank you.
Yes. So, Ms. Reddy, before we get on to the topic today, are there any latest immigration updates that we will have to know before we get it?
Yes, actually, very important update. As of April 28th, Friday, USCIS did announce the final count for the H-1B registration. So this is, of course, different from the perm topic that we've chosen for today, but the update is on the H-1B registrations as to how many registrations were picked, how many were duplicate. So they've given all that information. So I thought I'll run through that very quickly. With reference to the total registrations this year, there were 780,884. So that's a lot of registrations. It's double. Last year, the total registrations were 484,000. Almost that much. This year, 781,000 if we round it off. Out of that, the number of eligible registrations, meaning that, there's some people that register, but the registrations get cancelled because they didn't register properly or the payment didn't go through. So the eligible registrations are 759,000, rounding it off. So about 20,000 registrations were declared to be invalid. Out of that, 759,000, the eligible registrations for beneficiaries with only one registration. As we know, the problem and the reason for all these registrations is duplicate registrations. Now, beneficiaries are allowed to file more than one registration if through different employers, if there's a different job offer. So we've seen that employees have been filing 5, 10, 15, even 20 registrations per person. So if you look at only the persons who filed only one registration, that's 350,000 out of the 759,000. So that's half. The rest, actually more than half of that, more than half of the total have filed multiple registrations. So 408,000 registrations are multiple. Only 350 are single registrations. This is very significant. Last year, the eligible registrations were 474, and the single registrations out of that were 309. So almost all of them were single. About 165,000 were multiple registrations, and they picked 127,000 registrations last year. This year they're only picking 110,000, even though the number is so high. So 2 points to note. One is multiple registrations have skyrocketed. More than half the people have filed multiple registrations. And the pick number is lower than last time. Last time was 127, now it's 110. Now you have to remember they always pick more than the required 85,000 number because they think that some cases will get denied, some cases will not be filed, etc. The reason USCIS is saying they pick lesser number of cases is they're expecting more cases to get approved. That is not quite, doesn't make any sense to me, but because the approval rate was pretty good last year as well. So whatever, they have their reasons for picking, and unfortunately there's not much clarity, or there's not we don't know what's happening within USCIS, how many numbers are actually being used. So that's something that we just have to guess. I wish we had more transparency there, but we don't. So this time only 110. We don't know if there's going to be another lottery if the 85,000 number is not reached. And again, we don't know. There's no transparency as to how many numbers are actually being used. We have to go with what USCIS is telling us. So the other important factor in this year is, along with this data, USCIS is obviously very worried that the total pick rate was only 12% because of the number of cases that were filed. So USCIS is really worried about how this will affect the entire registration system, because it just the entire system is in upheaval because of the number of multiple filings that were done, and it's not being used effectively, the registration system, the way it was intended. Obviously not a lot of thought was put into it when they allowed the filing of duplicate petitions. So USCIS, in order to protect this H-1B registration rule and to make it effective, they're saying that this year they'll combat fraud in the registration process. They're saying that a large number of registrations were multiple registrations, which I've just told you, much larger than previous years. And this has raised serious concerns that some may have tried to gain an unfair advantage by working together to submit multiple registrations on the behalf of the same beneficiary. So while a beneficiary can file through multiple employers cannot collude with each other or have an agreement with each other to file for the same beneficiary, right? So the reverse is not possible. So if they see that 2 or 3 companies have conspired or colluded together to file for a bunch of beneficiaries to file the same list, if they see, like, for example, X Corp and Y Corp both have 30 employees, say, 30 registrations in common, they're immediately going to flag that, and they're going to send, if you file that H1, they're going to send notice of intent to revoke or notice of intent to deny. Now, I'm sorry I'm taking so much time, because this is a significant change in, at least something that the community should know. So their USCIS is saying that if they find collusion, which is not allowed, then they will refer those cases. Well, they have basically already undertaken extensive fraud investigations on those companies, denied and revoked petitions accordingly, and also initiated law enforcement referrals for criminal prosecution, because basically by falsely attesting to the fact that you will not collude. So basically, just to go back a little bit, when you're filing registrations, there was, this year at least, there was an attestation that you had to sign saying that you have not colluded with any other company to gain unfair advantage for a particular beneficiary or a group of beneficiaries. So if they find that that attestation was signed and it was not followed, then they might refer you for a criminal prosecution as well. So and they're saying that the H-1B program is an essential part of the immigration system and the economy, and USCIS is committed to implementing it and making sure that it works. And they're, of course, as I said, worried that it won't. And the way they're able to find out this whole multiple registrations and whether there is collusion, because it's very hard to show collusion, is they're saying that they have a software or they have an algorithm or AI which allows them to easily identify duplicate filings and to show and to see further identify if there's any relationship between the companies. So very important takeaway is that if you have colluded with some other company and filed multiple registrations along with that other company, multiple duplicate registrations, then please don't file those H1s, because you will be unnecessarily then putting yourself in jeopardy, and you might be referred even for criminal investigation other than just USCIS fraud investigation. So very important. But another important takeaway is that Simply because, say, for example, your employee files a registration with you and then files a registration with 6 other companies. That is allowed. That is not collusion because you did not discuss with the other companies and file the registration along with the other companies. That the beneficiary did, with or without your knowledge, it doesn't matter. So that is not collusion because beneficiary is allowed to approach other companies on their own and file multiple registrations. So please, a lot of people have been talking to me and asking me after this email came out from USCIS since Friday. I've been receiving a lot of phone calls from people who did not collude, but they think that they colluded because the beneficiary filed multiple registration. That's allowed by law. The beneficiary is allowed to file multiple registrations, but it's just that you're not allowed to get together with another company and file multiple registrations with that company. So as long as that collusion didn't happen, you're good. So that's my update with reference to H1B registrations
Yes.
and collusion. So now, Shivani, I know half the time has passed, but I thought that was an important update. And we'll start the perm. We'll start the perm session, and we can always take it into the next session if we're not able to finish
Definitely.
everything. So I thought that instead of just talking about perm audit triggers, we will actually go into a little bit more detail as to what to consider when filing a perm so that we don't get an audit, and then we'll go into some examples of audit triggers. So the key consideration when initiating a perm labor certification is you have to first think about your priority date backlogs, right? So one of the key consideration is priority date backlogs. What is a priority date backlog now? For India, China, and other countries, green card numbers are not available because the number of green cards issued every year is less compared to the number of green cards actually needed or filed. So what happens is there is this priority date table that is created because of that. And, the Department of State does this. They issue a visa bulletin every month. And if your priority date has reached as per the dates given on the visa bulletin, then you can actually file your green card, otherwise you cannot. So you will file the perm, you will file the I-140, and then you have to just wait for your priority date to become available to file the 485. So when we know that, there may be a long wait from the time of filing the perm to the time that the 485, the last step, is actually approved, there's some things to take into consideration because this could be many years before the final step is filed. And we want to make sure so that all the information in the perm still stays relevant after so many years, right? So to ensure that the perm labor certification continues to be valid when the foreign national actually applies for his or her green card, first you have to make sure that the job duties and skills remain relevant. So you have to, when you're filing a perm, you put in a certain job description. You have to make sure that that is continues to be relevant even several years from now. Business requirement, you have to make sure that you still need this person even after 5 to 10 years or 15 years. So you have to make sure that you can foresee that you have that requirement in the future as well. Employer should not change his office outside of the MSA. That's a big thing because employers, if they change outside of the state, outside of the metropolitan statistical area, which could be outside the county, for example, then even if it's within the same state sometimes, that could affect your labor certification and then filing of the I-140, that process. In addition, also filing of the 485. Make sure that the salary that you're offering is something that can be offered in the future also. Having said all that, minor changes in the duties don't really affect the labor certification. So even if there's some changes with the skill sets, say, you put some other skill sets, but now there's more updated skill sets now. And those skill sets, we know skill sets every 6 months, they become outdated. So if you have new skill sets, that should still be fine. For example, you're still employing that person as a software developer. They may not be working on C++, maybe they're working instead on Java now, or some other new skill sets that doesn't exist now. It's still fine. So those small changes won't affect the validity of the labor cert. So make sure you can prove the ability to pay, that you have the ability to pay the full-time salary from the date that the perm started to the date that the person actually gets a green card. So that can span to a period of 15 years. So as an employer, you should make sure that you continue to be able to have the ability to pay this person the prevailing wage. And this most straightforward way of demonstrating the ability to pay the prevailing wages if you actually pay it, and that is shown on the W-2. If you're not paying it, then the ability to pay can be shown through the tax returns by showing taxable income. So make sure that that happens. Another consideration because of the long wait is filing in EB2 versus EB3, which one is better? Employment-based category 2 versus employment-based category 3. As we all know, this is a roller coaster. Earlier, EB3, in October 2020, when there was this huge surge of filing labor certs, we saw that EB3 was ahead. So a lot of people downgraded from EB2 to EB3. And when a lot of people did that, obviously we know what will happen. The pendulum swung back the other way, and EB2 became available and ahead, and EB3 became backlogged. Then people again started filing all their cases in EB2. So you have to always make sure you know which priority date is better, and USCIS has established a process whereby you can change from one priority date to the other. When you're filing the perm, at the time of filing, just file in based on what the qualification of the beneficiary is, obviously, and what the need of the employer is. But also keep in mind what the priority date is for both EB2 and EB3 when you're filing, when you're drafting your job requirements.
Yes.
The next issue
So
yeah, go ahead. Sorry, Shubha.
yes, continue, Ms. Reddy.
The other issue to keep in mind is what do you do with reference to roving employees? Now, Department of Labor, when they first released this version of the PERM labor certification filing, it was in 2005. And as of a survey done in 2003, only 54% of the homes in America had internet access. So there was no question of anyone working from home or, but that obviously we know that has changed now, and even more so with COVID. But since that regulation was was written in 2005, the Labor Department, the PERM regulations are woefully inadequate to address the present day issues of telecommuting and traveling employees, both employees. So what is the difference between roving versus telecommuting? So telecommuting is basically you are working from home. You're working remotely. Roving is when you go to different places to work. So you have employees or clients at different sites, which keeps changing. Either it could be something that changes every week because you have to go, your employer has different clients, or it could be that you go to one project, go to one client, and maybe 6 months later you have to change to another project becomes available, then you have to go to another client. So that is roving versus telecommuting is working remotely. Working remotely could be from the person's home or could be from the employer's office. So if you have a roving or a telecommuting situation, then the question becomes with the perm, where to advertise. Do you advertise at at your home if you're working? Do you from your home location? Say you're working from California and your employer is in Texas. Do you do the advertisement process? The advertisement process is required for all perm applications. To Sunday newspapers, online, website. So there are different kinds of ads that are required, and you're required to post those ads generally based on wherever you're working. So in this case, if you don't know where you're going to work because you keep changing your workplace, or you're working from home, what is the appropriate place to do the advertisement from? And USCIS has established, based on Barbara Farmer memo, there was a memo that was issued where they said that if it's a roving employee or telecommuting employee, the place of advertisement should be the employer's primary office. Wherever your employer's primary office is, main office is, that's where you need to advertise. So that's one another issue. Then there are a lot of with reference to this. There have been a lot of audits. There have been RFEs. There's certain language that is required. So if you do have a roving employee, you're supposed to put within the duties travel and/or relocation to various unanticipated client sites with the United States may be required, because this telecommuting and roving is considered to be a benefit. I don't know why it's a benefit, but DOL considers it to be a benefit. So since it's a benefit that you're offering your employees, you have to put it in the advertisement and you have to put it in your job description as well. So that's something to keep in mind. So another issue when you file PERMs is how do you draft the advertisement and the job requirements in the PERM? Now, there is obviously financial consideration because you have to place advertisements, and the larger the ad, the more expensive it will be to place the advertisement, and it has to be done in 2 Sundays and other places as well. So one of the key things is to keep your ad and keep your job description also short and sweet. What we usually do is, of course, there is guidance from with reference to the ad as to what has to be mentioned, and with reference to what has to be mentioned, the name of employer, the geographic area of employment, a brief description of the position, just enough to apprise the reader of what the position is actually about, and minimum education experience requirements. These are the things that are, and of course the traveling or telecommuting requirement, like the language that I just read. So these are some of the some things that have to be mentioned in the ad. So usually what I do is I put in a brief job description, I put in the skill sets. If it's a single ad, if I'm doing multiple ads, I just say various skills required. What I mean to say by multiple ads is if I'm doing an ad for several people in one ad, then I'll just put various skill sets required. I don't list every skill set. While I list it in the job duties, I don't list it in the advertisement. So that's what every attorney has their own way of doing it. Also, it might make sense to say when you're putting skills, knowledge of skills instead of experience in skills, because if the beneficiary doesn't have previous experience, then you can't put prior experience needed in XYZ skills. Because if you put in any special requirements, you have to show that the person had those special requirements before they joined the company. You can't submit an experience letter from the employer. Okay. With reference to whether should you put masters, should you put bachelors, what I usually do is most of the jobs, they have dumbed them down. If you look at the SVP or the ONET codes or the DOL instructions, they say that most positions require only a bachelor's degree. But we do a lot of senior positions like senior software engineer, senior systems analyst, senior data scientist. We do put in a master's requirement, even though the DOL says that the normal qualifications is only a bachelor's. And then if necessary, we put in a business necessity letter as and when needed to show why a master's or why more experience is needed for this candidate, which qualifies them for an EB2 position. So don't be afraid to use qualifications above that what the DOL says is normal. as long as you're able to justify it. You can use experience gained with the petitioning employer. I know I just told you that you have to show that the qualifications that the person has were obtained before they actually started with this employer. But if they don't have previous experience, you can use experience from the present employer. But that's only if the job is that they're presently working in is at least 50% different from the job that they're filing the green card for. So say if they're presently working as a programmer analyst and you're filing the green card for a systems analyst or a data scientist, you have to show the job description, compare and contrast it, and show that it's at least 50% different in order for DOL to accept the experience gained with the petitioning employer.
Yes.
So you can also use experience which is not exactly the same as the present experience. So you can say that we'll accept any experience, any reasonably related experience. And there's been some controversy about this, and that, we'll leave that for another time as to what language to put in if you're willing to accept experience other than a software engineer, if the job title for your perm is a software engineer. Okay.
I think, Ms. Reddy, the time is almost up, but I think the next episode we can definitely, discuss more in detail about some other audit triggers. So yeah, let's continue this next week. But again, thank you so much for tuning in. Thank you to the viewers also for tuning in. You're watching Sakshi TV with me, Shivani Raj.
Thanks, Shivani.